Start. Again, in the same case, Honorable Ethics Code has expressed about various alternative steps to be taken in the matter of loss of records in Para 10 of the judgment, which is extracted as herein below. Para, we therefore set aside the order of the High Court and remit the matter back for fresh consideration. It is to be noted at this juncture that one of the respondents, that is, Om Pal, has died during the pendency of the appeal before this court. The High Court shall direct reconstruction of the records within a period of 6 months from the date of receipt of our judgment from all available or possible sources with the assistance of the prosecuting agency as well as the defending parties and their respective counsels. If it is possible to have the records reconstructed to enable the High Court itself to hear and dispose of the appeals in the manner envisaged under section 386 of the Code, rehear the appeals and dispose of the same on its own merits and in accordance with the law. If it finds that reconstruction is not practicable but by order, retrial interest of justice could be better served, adopt that course and direct retrial, and from that stage law shall take its normal course. If only reconstruction is not possible to facilitate High Court to hear and dispose of the appeals, and the further course of retrial and fresh adjudication by Sessions Court is also rendered impossible due to loss of vitally important basic records. In that case and situation only, the direction given in the reviewed judgment shall be and shall create, and the matter shall stand closed. The appeals are accordingly disposed of. Para, in a similar case where lower court record was not available and reconstruction of record did not succeed, a division bench of this court has, in the case of Sitaram and others versus State, 1981 CRL LJ 65, made observation in Para 11, which is quoted herein below. Para, on a careful consideration of the relevant statutory provisions and the principle laid down in the cases cited before us, we are of the opinion that where it is not possible to reconstruct the record which has been lost or destroyed, it is not legally permissible for the appellate court to affirm the conviction of the appellant, since perusal of the record of the case is one of the essential elements of the hearing of the appeal. Stop. The appellant has a right to try to satisfy the appellate court that the material on record did not justify his conviction, and that right cannot be denied to him. Stop. We are further of the opinion that if the time lag between the date of the incident and the date on which the appeal comes up for hearing is short, the proper course would be to direct retrial of the case, since witnesses, and it would not cause undue strain on the memory of witnesses. Stop. Copies of FIR, statements of witnesses under section 161 CRPC, reports of medical examination, etc. would also be normally available if the time gap between the incident and the order of retrial is not unduly long. Stop. where however the matter comes for consideration after a long gap of years, it would neither be just nor proper to direct retrial of the case, more so when even copies of FIR and statements of witnesses under section 161 CRPC and other relevant papers have been weeded out or are otherwise not available from. In such a situation, even if witnesses are available, apart from the fact that heavy strain would be put on the memory of witnesses, it would not be possible to test their statements made at the trial with reference to the earlier version of this incident and the statements of witnesses recorded during investigation stop. Not only that, the accused will be prejudiced, but even the prosecution would be greatly handicapped in establishing its case, and the trial would be reduced to a mere formality, entailing agony and hardship to the accused and waste of time, money and energy of the state bar. In the above referred case of Sitaram Supra, the division bench acquitted the accused in view of the fact that the lower court records could not be reconstructed. This aspect of Sitaram case Supra was again considered by another division bench of this court in the case of Ram Nath versus State 1982 open bracket 19 close bracket ACC 128 open bracket decided on 3/11/1981 close bracket, wherein also following observations were made. After making the aforementioned observations and in view of the fact that the court was not in a position to have the record of the case reconstructed, the bench directed acquittal of the accused in that case. The principle laid down in Sitaram's case fully applies to the facts of the present case. As all attempts to have the record reconstructed have failed, this court is not in a position to affirm the conviction recorded by the trial court. So far as the question of ordering a retrial is concerned, we find that in the instant case, the incident in connection with which the accused were prosecuted took place as far as 13/9/1970, that is more than 11 years earlier. In such circumstances, it will not be desirable to direct a retrial. In this view of the matter, we have no option but to allow criminal appeal number 857 of 1976 and to set aside the conviction and sentence of Ramnath and to acquit him of the offence with which he has been charged. In similar circumstances, another division bench of this court in the case of Brahmanand Sukla versus State of UP 2010 open bracket 2 close bracket all JIC 179 open bracket SC close bracket 2010 open bracket 69 close bracket ACC 749 made following observation in para 10 para. In the present case, as we have mentioned in the earlier part of the judgment, only a copy of the trial court's judgment is available and no other documents like FIR, post-mortem report, copies of the documents which had been filed by the prosecution and were exhibited during trial. The statement of the witnesses recorded under section 161 CRPC are available despite various attempts to reconstruct the record. The incident is of the year 1979, that is, the incident took place about 30 years back. In these circumstances, no fruitful purpose would be served by ordering retrial, as the same cannot be conducted at all in absence of these documents. In the light of the above discussions and circumstances mentioned above, we have no other alternative, but to allow the appeal, set aside the conviction on sentence of the appellant and to acquit him para. In similar circumstances, another division bench of this court in the case of Sitaram and others versus State made following observation in para 12 and 13 para. In the present case, the incident took place on 23/8/1971. The appellants were convicted by the Sessions Court by an order dated 18/11/1974. The appeal has been pending in this court for about 6 years. We are informed that copies of the first information report and statements of witnesses recorded under section 161 CRPC have been weeded out and are not available. All attempts to reconstruct the order have proved futile. In such a situation, it is not permissible for us to affirm the order of conviction of the appellants, since in the absence of the receipt, we cannot possibly feel satisfied that the appellants have been rightly convicted due to lapse of time and non-availability of papers like first information report, statements under section 161, criminal procedure code, etc. We do not consider it either just too expedient to order retrial of the case para. In these circumstances, the appeal is allowed. The order of the court below convicting and sentencing the appellants is set aside as they are acquitted. They are on bail. They need not surrender. Their bail bonds are discharged para. In similar circumstances, another division bench of this court in the case of Kesari and others versus State of UP 1988 JIC 355 made following observation in para 3 and 4 para. Under these circumstances, the lower court's record should not be obtained, and without the same, the appeal cannot be heard on merits. It appears that the reconstruction of the record is also not possible, inasmuch as original documents have all burnt out para. Under these circumstances, both the appeals stand alone and the conviction of the appellants and sentences awarded to them are hereby set aside. They are on bail. They need not surrender. Their bail bonds and securities stand discharged para. In view of the above discussion, considering the judgment of the apex court and of this court, since in spite of best efforts, neither reconstruction of record is possible nor retrial is possible. Hence, the criminal appeal cannot be directed to merit in absence of relevant prosecution papers, including the statement of witnesses, and as such, there is no option but to set aside the imputed judgment of conviction. In view of the fact, the judgment and order of conviction on sentence dated 16/10/1981 passed by 5th Additional District and Session Judge Bijnor in session trial number 357/79 under sections 147, 148, 302/149 IPC, PS Chandpur District Bijnor is hereby set aside para. Accordingly, the present appeal is allowed. The appellants are on bail. The securities shall stand discharged. The need paragraph starts. As far as the injuries sustained by the deceased as well as PWs 8 and 11, the High Court has noted specifically about the injuries as was noted by PW9 in the post-mortem report, which was inflicted on the deceased at the time of occurrence, which, when compared with the oral evidence spoken to by PW8, the High Court has found that the same fully tallied with the oral evidence of PW8. In paragraph 14, the High Court has noted the various injuries and evidence of PWA in support of the said injuries. Similarly, in paragraphs 15 and 16, the High Court has referred to the injuries sustained by PWs 8 and 11, which were spoken to by PW 12, who attended on them and has found that the evidence of PWs 8 and 11 was fully corroborated by the medical evidence, and thus there was no scope to doubt their version as to the manner in which the injuries were inflicted on the deceased, as well as the injured PWs 8 and 11. Thus we find that the appreciation of evidence of the eyewitnesses account, the supporting version of the other witnesses, read along with the expert medical opinion, again supported by the post-mortem report and the injury report. There is no reason to take a different view than what has been taken by the revision bench in the impugned judgment. When we consider the submission of the appellants, in the first place it was contended that the participation of the 5 accused would not duly made out. As far as the said contention is concerned, we have noted extensively the evidence both oral as well as documentary to show as to how all the 5 accused were duly present at the place of occurrence. In order to attract section 149 IPC, we have also found that based on the medical evidence as well as on the injured eyewitnesses account, to show how the appellants revealed their common object in the course of their participation, when the deceased and the injured witnesses were inflicted with serious injuries with the aid of deadly weapons, and consequently none of the accused could escape from the invocation of section 149 IPC. In the murder of the deceased falling under section 302 IPC, as well as the grievous injuries caused on PWs 8 and 11. तीसरा पढ़ेंगे। हिमानी चौथा पढ़ेंगे। Ready? Start. Coming to the issue of non-examination of the injured witness Ganga Singh, it is relevant to point out that the trial court had appreciated the fact that though the prosecution had made an attempt to produce Ganga Singh, they failed to do so, as he was kidnapped at the relevant period. This stands proved by the expression of Tukatwaya dated 12/9/97 and 6/10/97, which established the fact that Ganga Singh was threatened and kidnapped. Therefore, non-examination of injured Ganga Singh could not be fatal to the case of the prosecution, and the same cannot be a ground to disregard the evidence of PWs 1 and 2. Thus, no adverse inference can be drawn against the prosecution for not examining Ganga Singh, the injured witness. Also see Rajan Rai versus State of Bihar, 2006, open bracket 1, close bracket all, JIC 308 SC, 2006 1 SCC 191. As far as the non-examination of any other independent witness is concerned, there is no doubt that the prosecution has not been able to produce any independent witness, but the prosecution case cannot be doubted on this ground alone. In these days, civilized people are generally insensitive to come forward to give any statement in respect of any criminal offence unless it is inevitable. People normally keep away from the court as they feel it distressing and stressful. Though this kind of human behavior is indeed unfortunate, but it is a normal phenomena. We cannot ignore this handicap of the investigating agency in discharging their duty. We cannot derail the entire case on the mere ground of absence of independent witnesses. As long as the evidence of the eyewitness, though interested, is trustworthy, para. It has been vehemently argued by the accused respondents that the prosecution has failed to establish any motive for the alleged incident. However, the complainant had deposed about existence of land dispute between the parties and regarding the same. Complaints were made prior to the incident also. The trial court held that there was land dispute between the parties and for the same, complainant had made complaints to the police. Open bracket Exhibit K2 and K3. We concur with the view of the trial court that the accused respondents had enmity with the complaining party over a land dispute and that Exhibit K2 and K3. The complaints made prior to the incident could not be an afterthought as both the exhibits bear signature and dates on which these were received by the police. Thus, in the light of our discussion, it can be safely held that the accused respondents had a strong motive to commit the offence against the complaining party, because the same is, however, not true in case of a plant Jagtar Singh. There is clear, clinching and unambiguous evidence on the record in the statements of PW3 Harbans Singh and PW4 Gurmeet Singh to the effect that it was he who got hold of Surinder Singh, deceased, by Later's beard and hair, felled him upon ground and hit his head twice or thrice against ground. It was on account of that hit that Surinder Singh became unconscious on the spot, though a plant Jagtar Singh did make an attempt abortive to raise above indicated plea in the statement under section 313 CRPC, but that plea does not stand proved on record if there was an iota of truth in the above notice plea of a plant Jagtar Singh to the effect that matter was under discussion in the presence of certain common relations. There is no reason why he could not have named them or examined at least one or two of them at the trial. Their testimony could be supportive of the plea raised by Jagtar Singh, appellant at the trial. Para. We have also on our part perused the ocular evidence and having so perused are inclined to concur with the aforementioned view of the High Court calling no interference part. The evidence in our opinion does not prove that it was the appellant who took the lead, caught hold of deceased by his hand, pulled him down to the ground and hit him on his head. The injury in the head resulted the deceased first becoming unconscious and later succumbed to it. The ocular evidence on this issue was properly appreciated by the trial court and the High Court for holding the appellant guilty for committing the offence in question, and hence it deserves to be upheld. Para. We have not been able to notice any kind of inconsistency or exaggeration in the evidence adduced by the prosecution on this material issue, so as to disbelieve the evidence of eyewitnesses on account, and hence we concur with the finding of the High Court quoted above and reject the submission of the learned counsel for the appellant. The preamble indicates that the act was passed as it was expedient to make more effective provisions for the prevention of bribery and corruption. The long title as well as the preamble indicate that the act was passed to put down the said social evil, that is bribery and corruption by public servant. Bribery is form of corruption. The fact that in addition to the word bribery, the word corruption is used shows that the legislation was intended to combat also other evil in addition to bribery. The existing law, that is penal code, was found insufficient to eradicate or even to control the growing evil of bribery and corruption, corroding the public service of our country. The provisions broadly include the existing offences under sections 161 and 165 of the Indian Penal Code committed by public servants and enact a new rule of presumptive evidence against the accused. The Act also creates a new offence of criminal misconduct by public servants, though to some extent it overlaps on the pre-existing offences and enacts a rebuttable presumption contrary to the well-known principles of criminal jurisprudence. It also aims to protect honest public servants from harassment by prescribing that the investigation against them could be made only by police officials of particular status and by making the sanction of the government or other appropriate officer a precondition for their prosecution, as it is a socially useful measure conceived in public interest. It should be liberally construed so as to bring about the desired object, that is to prevent corruption among public servants and to prevent harassment of the honest among them. A decision by the Judicial Committee in Dyke versus Elliott 1872 PC 184 cited by the Learned Counsel as an aid for reconstruction neatly states that principle and therefore may be extracted. Lord Justice James is speaking for the board said the same at page 191. No doubt all penal statutes are to be construed strictly. That is to say, the court must see that the thing charged as an offence is within the plain meaning of the words used and must not strain the words on any notion that there has been a slip, that there has been a cases of malafide. The position that emerges from the above discussion can be summarized thus: the power of the High Court in quashing a criminal proceeding or FIR or complaint in exercise of its inherent jurisdiction is distinct and different from the power given to a criminal court for compounding the offences under section 320 of the Code Stock. Inherent power is of wide plenitude with no statutory limitation, but up to be exercised in accord with the guidelines engrafted in such power, namely, point 1, to secure the ends of justice, or point 2, to prevent abuse of the process of any court. Stop. In what cases power to quash the criminal proceeding or complaint or FIR may be exercised where the offender and victim have settled their dispute would depend on the facts and circumstances of each case, and no category 3 can be prescribed. Stop. However, before exercise of such power, the High Court must have due regard to the nature and gravity of the crime. Stop. Heinous and serious offences of mental depravity or offences like murder, rape, dacoity, etc. cannot be fittingly quashed even though the victim or victim's family and the offender have settled the dispute. Stop. Such offences are not private in nature and have serious impact on society. Stop. Similarly, any compromise between the victim and offender in relation to the offences under special statutes like Prevention of Corruption Act or the offences committed by public servants while working in that capacity, etc., cannot provide for any basis for quashing criminal proceedings involving such offences. Stop. But the criminal cases having overwhelming and predominantly civil flavor stand on different footing for the purposes of quashing, particularly the offences arising from commercial, financial, mercantile, civil, partnership or such like transactions, or the offences arising out of matrimony relating to dowry, etc., or the family disputes where the wrong is basically private or personal in nature and the parties have resolved their entire dispute. Stop. In this category of cases, High Court may quash criminal proceedings if in its view, because of the compromise between the offender and victim, the possibility of conviction is remote and bleak, and continuation of criminal case would put accused to great oppression and prejudice, and extreme injustice would be caused to him by not quashing the criminal case despite full and complete settlement and compromise with the victim's stop. In other words, the High Court must consider whether it would be unfair or contrary to the interest of justice to continue with the criminal proceeding, or continuation of the criminal proceeding would tantamount to abuse of process of law despite settlement and compromise between the victim and wrongdoer, and whether to secure the ends of justice, it is appropriate that criminal case is put to an end, and if the answer to the above question is in affirmative, the High Court shall be well within its jurisdiction to quash the criminal proceeding.